Ladies and gentlemen, good morning to all of you. Welcome to the second day of the symposium that celebrates the 10th anniversary of the CTC, the internalization of the convention and its protocol here by Brazil. The main objective of the event is to celebrate the 10th anniversary of the incorporation of the convention into Brazil and to gather teams from ANAC and national and international experts to analyze the advances, the main problems, and the main challenges that involve the application of this law, and especially its practical repercussions here in the civil aviation sector. Before continuing, this event is also being transmitted by the official channel of ANAC on YouTube, and it has two broadcasting channels, one with the original audio and the other one with simultaneous translation into Portuguese and into English. So the questions to the speakers are going to be asked after the panel, and you're going to be able to use the wireless microphones handed to you by the receptionist. So we are starting now today's event with the following debate: international relations and compliance with the foreign judicial orders related to the CTC in Brazil. And we would like to invite onto the stage His Excellency Magistrate Mr. Marcelo Dinardi, Magistrate of the Federal Regional Court of the Fourth Region, and he is the president, he's the chairman of the General Affairs Council, and he's also a member of the Hague Hague Court. Ms. Renata Duarte Iese, attorney at Bosch and Ramé Law Firm. Mr. Fábio Komatsu Falkenberger, attorney at the Machado Meyer Sendax Opus Law Firm. Ms. Inês Lopes de Farias, professor of the University of Brasília. And to be the moderator of this panel, we would like to invite Mr. Kenneth Roth, member of the Aviation Working Group. Good morning, ladies and gentlemen. Thank you so much for being here today. Thank you to all of you who are watching us on YouTube. I believe that yesterday we had about 300 people watching the symposium on YouTube. And so we had a good audience here in the auditorium, as well as all over the country and maybe all over the world. And once again, I would like to thank ANAC for having organized this symposium, which is very important for the AWG group, the Aviation Working Group, to celebrate the 10th anniversary of the adoption and implementation of the CTC here in Brazil. Yesterday was a very interesting day, and we hope that today and this morning we're going to continue with debates about essential topics for the aviation sector. On this panel, we are going to focus on certain issues that were discussed yesterday, and maybe we are going to go deeper, a little deeper, because now we have four experts with us, and they have vast experience on the matter and from different perspectives. We have a magistrate, we have a professor, two attorneys that are working currently, that are currently working. So we're going to have a diversity of perspectives regarding these topics, mainly when it comes to international cooperation. So the Cape Town Convention, the CTC, has some terms and some deadlines, mainly some deadlines that are very challenging to be implemented in several countries and also in Brazil. So I would like to start this debate among the experts by asking you, mainly about a declaration in Brazil regarding Article 13 of the Convention that sets forth 10 business days for the implementation of cautionary measures. We know that this has already worked in the judiciary branch in Brazil, but now we're going to debate this topic when it comes to the international arena, considering an order or a sentence from a judge or from a court from another country, assuming that is another signatory state. So I would like all of you, please. The order that you're going to speak doesn't matter. So who would like to go first? Okay, so Mr. Magistrate, thank you very much. Good morning to all of you. Thank you so much for the invitation. It's a great honor to be here, followed by highly qualified panelists, okay? I don't practice this topic on a daily basis, but I develop academic topics in The Hague jointly with Miss Inês and also legal international cooperation and also with Miss Renata. And so maybe this is one of the points, one of the important points on how to coordinate, how to adjust the effectiveness of the legislation and combine it with the national legislation so that we can reach the specific point of the deadline. So from my personal understanding, it seems to me that the jurisprudence of the Superior Court in Brazil regarding international treaty, and I'm coming back to Brazil, okay, because I believe that was your question. And I can see that the interpretation of the STJ, the Brazilian Superior Court, and this is a better solution in a topic related to the air transportation, the transportation of passengers, mailing, the prevalence of the consumers code that we have. And regarding the treaty, I believe that it is exactly the best conductor of the jurisprudence of the STJ when it comes to the speciality. And so the speciality of the treaty, and I believe the answer would be the easiest one. So the treaties clause is the one that is going to be valid, and that would be my answer if I was asked by a student. But life is not so easy. We have a great issue because I know the treaty, know how to interpret it in a uniform way, and this is how it's being interpreted, okay? And so what does it mean to get to know the precedents, to get to know what happened in other countries regarding the implementation of certain measures when it comes to an urgent or emergency matter, because we're talking about a cautionary measure. And I know that some judges, they are have an overload of work. And so the burden on top of a single human being and me, I would remind the Judge Hercules. How can we arrive at this knowledge? Highly specialized knowledge, as my colleagues well know, and you have to know this matter deep down. And so, a little bit of humanity would be important here. But what are we doing here? When it comes to the advantage of the deadline, we have a problem because the treaty mentions a model that interferes in the procedural counting or countdown of the deadline and what prevails in terms of lawsuits. And I would like to ask you to excuse me. So, what is the judicial lawsuit or the procedures? What are the procedures regarding the treaty, the commitments that result from the treaty? So, the exercise of the judicial process is the power, state power, sovereign power. And traditionally speaking, Professor Inez, we discussed this for a long time. In terms of lawsuits, the general rule is the Brazilian legislation should prevail. So it's difficult for us to interpret it because we have one treaty that potentially speaking discusses a topic that involves procedural matters, and we can even argue if it is a procedural deadline or not. And there is a general rule that what is going to prevail is the Brazilian legislation. But we also have the international treaties. But please notice the number of conditions that are necessary to make a decision and in a lawsuit that is going to impact one of the parties economically in a huge way. That is the major difficulty whenever we make a decision when it comes to this deadline. So my first answer is the internal legislation should prevail, but we have to consider the Article 13 of the procedural books. And so the 10-day deadline, and our deadline is 5 days. No, it's not 5 days. There is no deadline. So the urgent measures, they are assessed depending on the urgency of the matter. And according to the general procedural rules, the judge can go a little bit over, offer the opportunity for the other attorney to answer or respond to that. And the Constitution gives a certain guarantee or collateral based on the judicial sentence. And so they overlap when it comes to the countdown of the deadline, the real countdown of the deadline at a certain moment. So to wrap up, I recognize that the treaty sets forth the deadline, and I believe that the deadline should prevail, and the deadline which is depending on the efficacy of the measure, and this is even more serious. You're going to sit in front of a computer and type down your sentence, but sometimes it's difficult to make it become something real. And judges should be aware of this and pay attention to this. So, in the bottom line, Article 13 of the Civil Code sets forth the deadline of the treaty, but the treaty is not enough to avoid the judges to take their own measures. Thank you very much. Thank you very much, Professor. Good morning, ladies and gentlemen. First of all, I would like to thank Dr. Luciana, Dr. Natalia for the invitation. I would like to invite all of the people present here. Thank you, Dr. Marcelo Dinardi. I would like to invite all of you, thank all of you for being interested in this topic, and thank you to the UNB students who are present here today. UNB is the University of Brasilia. Well, when it comes to the applications of the cautionary measures or the emergency measures, something that was well mentioned by Dr. Marcelo is part of a juridical system that belongs to Brazil. It's an internal system because to comply with this order, we have to consider the internal scenario. Let's consider the question. We have the CTC setting forth that we should adopt the 10-day deadline of the emergency measures and the 10-day deadline. Internally speaking, this is possible. Internationally speaking, we don't have the free circulation of foreign rules, decisions, or orders. And so in The Hague in 2019, me and Professor Marcelo, we had the honor of being part of the group that discussed the diplomatic session, and it's not in effect. So that happened in 2019. So the idea of a treaty based on a free circulation of the sentences Professor Valmer, he mentioned that in the 1990s, and it was not fruitful because we have the jurisdiction that is an attribute of the sovereignty of the states. And so we move forward to establish the Hague Convention, so we can choose the location of the lawsuit where it's going to be judged. And now we have an international forum for international sentences. And then we have the indirect jurisdiction for this. And our civil procedural code wants to adopt the international sentence, but the complexity of the international law is that you don't only have the Hague Convention, you have another convention that rules over international matters. And the Cape Town Convention sets forth the cautionary measures, but does not establish the mechanisms so that these mechanisms are going to be contemplated inside the convention. What it sets forth is, since the states, based on their internal legislation, they can cooperate for the Article 13 to be respected, and then when the order is an international order, there is a time for it to be analyzed. So there are no automatic effects of a decision. A foreign order, a definitive foreign order, a cautionary measure. And please bear in mind that in Brazil, up until the 1990s, Brazil did not accept transborder cautionary measures. So within the Mercosur, this was not applied. When the Supreme Court changed this to the STJ as the competent body to ratify the international decision, then we started ratifying the urgency tutelage or measures. It's important to highlight that the international legal cooperation is based on trustworthiness, and we trust in one another, and this has to be a formal instrument, and each instrument is unique, and this varies. So within the OAS, so you're going to have a request to recognize international sentences. In Mercosur, it's going to be different. And so we are going to only implement the emergency measures and not the cooperation instruments that would promote this speed. Now, mentioning the international cooperation, we have the possibility of using these technologies to facilitate certain emergency measures. There is a measure within the Hague Convention when it comes to alimony and child support abroad, in which we have a platform within the Hague Convention and within the European Union, so that certain child support decisions can circulate faster. And maybe it would be necessary to think about the Hydro A, to think about an institutional mechanisms in which the states should establish a platform, a communication platform between the authorities of different states, so that some urgency tutelage measures could circulate within 10 days, because then you would have an electronic platform to do that. That started working in Brazil, if I'm not mistaken, in 2020 or 2021, it came into effect. Queima Possída. We have the electronic apostilles, and this is being done faster than the communication between the authorities. So maybe we should create a mechanism to truly make this deadline come into effect, and this 10-day deadline, maybe it's going to depend on an instrument within the ONIDRO A, so that this can happen and we can acknowledge the commitment of the states to recognize this order, international legal order, so that this emergency measure can be implemented in Brazil. And we can use central authorities that are going to be nominated, and we can also have an emergency internal lawsuit created by the STJ, because we would have not to need the rectification within the instrument also. Some treaties, they exempt the acknowledgement, and when you exempt the acknowledgement and you allow the execution, because we have two phases. One is the recognition of the order that was issued by a foreign judge, and the other issue is the enforcement of this decision in the state. That's why the Hague Convention is a double convention, because it establishes not only the obligation of, recognizing, and also the enforcement of the international order. These are my comments. Thank you.
Thank you so much. I'd just like to add something which could potentially be interesting. The International Registry of Aircraft has something called a Trusted Communication Facility, which has authenticated messages which could potentially be used in the way that you have described. Perfect. Well, I think that's an important issue because we already have an international registry system, and this would give structural support to this and feasibility to the promotion of this legal safety, which is necessary to keep this mutual trust between states. Dr. Hinata, Dr. Fabio, you can comment from the point of view of lawyers who are in practice working in uh, relation to the convention and to creditors that have interest in the convention. Well, first and foremost, I'd like to thank Anaki, Luciana, and Paula for their patience and the time they spent organizing this. And Anaki, I'd like to congratulate Anaki for the uh, grade 5 on the compliance index. I think they deserve a round of applause, don't they? Well, I have the unhappiness of speaking after two specialists, more than specialists on international treaties, but I think I don't have that much to add. Obviously, I'm a defender of the 10-day deadline. I think it's very complicated with the legal infrastructure that we have here in Brazil to be able to fulfill this deadline. Above all, well, well, for foreign sentences, that's hard. But even for an intermediary order, it's very complicated because I'm going to be depending. I'm going to be depending on the rogatory, and I can't escape this even with an extrajudicial letter. And unfortunately, it's very complicated. I don't need to say this here, but was something that was mentioned yesterday, which I think is the solution to this topic, is that happily we have the option of asking for a cautionary measure directly in Brazil, which I think that would be the easier route instead of depending on the approval of a foreign relation, even if we have, well, even if there's something, there's an abeyance of a foreign decision, but this 10-day deadline is basically unfeasible. I think you already approached everything that needed to be approached from the point of view of international relations. Good morning, everyone. Well, Hanata mentioned that she was unlucky to go after two specialists. Mine is even worse because I'm not going after three. Anyway, I have a question, a doubt. Here in Brazil, in relation to the entire framework of civil uh, lawsuits here, the 10 days aren't a reality. And we need something to deal with this discussion on the 10 days or an approval of an international sentence. What we have are precedents that we try to bring to be executed in Brazil, these in foreign countries, and then we have some precedents which are a little bit more positive in this sense, in the measure that, well, I was talking to my colleagues at the office that they were able to get a cautionary measure to get in the STJ during the approval process so that this approval process was faster in the sense that we had periculo in mora, a danger of a state. These are the prerequisites of a cautionary measure. But this is not something specific for the CTC, and it still wasn't in less than 10 days, right? So the idea is that you should have a cooperation system that is certified. Seems like the way to solve this problem. And I wanted to know more from Dr. Marcel and Dr. Inez. What do we need to establish this? What are the steps that we need to go through? What is the founding measure that we can take to solve this problem? Well, when these questions come, I feel, well, if I was a dictator, if I ruled over everything, this is the way things would be. So that's more or less what my answer would be like. Oh, I woke up this morning, I'm going to solve this problem. But I see two possibilities that might be interesting. One is exclusively Brazilian, and the other one would be following more or less what Professor Inez said. The first possibility, and now I'm using the lessons of Professor André de Carvalho Ramos, even though he wasn't so exclusively dedicated to this, is that we have the hypotheses of a waiver for these. Well, we have one already, which is for simple divorces that don't have any sort of issue with the with goods or who gets the child care. Anyway, from this point of view, which is a lot more reachable with a purely Brazilian political movement, is editing a regular law which excludes this kind of measure from the need of recognizing the approval of an international sentence. We wrote about this, right, Professor? We wrote about an article about this together. So that's one possibility, and we would establish rules based on the international registry, the ARBAC, the ARBAC. So this could be a more specific possibility with more safety if we had a well-established rule. That's one possibility that eliminates the issue of the recognition of international sentences. The next possibility, which I think is harder to do politically, is what Professor Inez mentioned, using ICAL, Hydroway. Those worked very intensely on the development of CTC. Well, that would be an initiative for an international treaty, the development of which, looking at our limited experience, right, Professor Inez, I think that would be very hard to develop, as was the Cape Town Convention as well. So I think it would demand more time and political effort, not only in developing this treaty, but also in making it effective in the signatory countries. But I don't have this mandate yet, so, well, you have my vote. I think the issue is do we know of any precedents? And I also ask Ken, of a country outside Brazil, another jurisdiction that is also subject to the Article 13 deadlines, the way that they were declared, it might be different from Brazil, but which in which in fact this works, this approval of these sentences around the world. Do we have any precedents? I don't think it's been tested yet. Specific this possibility hasn't been tested yet. When aircrafts operated by Russian companies were going back to Russia after the start of the Ukraine war, there were some attempts of getting these aircraft from with orders from other countries, but I don't think they were successful. But there are other considerations that, Vladimir Putin, things like that. There's other issues involved, let's say. They tended to repossess these. But as far as I know, I think I could go further in depth to verify, but I don't think this has actually been tested. So even though we're debating or recognizing the difficulties you have here in Brazil, we shouldn't think that it's easy in other countries. It's not easy in any country. However, we do need to face this and to try and find means of applying the convention because at the end of the day, that's our law. That's the law of these 86 countries. Now maybe we should go to an issue that's related to this, also related to international cooperation. It's a variation, so to speak. And we'll start with Fabio so that he's not always the last. He also has a certain advantage here because last month I watched him discussing this in another environment in London about some issues on international insolvency. So let's say a Brazilian company is in the COMI, the main interest hub. So this company, instead of asking for bankruptcy in Brazil, they ask for the Chapter 11 protection in New York. Usually, the American judiciary accepts these cases easily. There's no need to have a lot of contact, so almost any airline could ask for this. And I'd like to ask, what do you think the Brazilian judiciary would act like here? Or having said that better, or saying that better, what are the procedures that would take place in Brazil in a situation like this? Well, in that case, we have the bankruptcy law, which was recently changed to foresee procedures of transnational insolvency, which foresees the cooperation and faster communication between bankruptcy judges in different jurisdictions. So, in the Brazilian bankruptcy law, the first step would be for the uh, for the debtor to ask for the approval of the Chapter 11 asked for in foreign jurisdiction. In relation to the CTC, well, it's very clear there in Article 30 of the protocol that in cases in which the insolvency was started in a country, signatory country, and Chapter 11 would be a case, it would be the obligation of the foreign judge to apply the convention according to what Brazil applies with Brazil's declarations. In the case, well, the center of main interest should be Brazil if the company is headquartered in Brazil and has most of its business in Brazil. So, by the convention itself, these are two signatory countries. If you have a global stay or or waiting period that's above what Brazil foresees, which is 15 days, this would be a breakage of the convention by the American judiciary. And we've seen this happen in the case of Avianca and Ocean Air. The decision was of keeping the deadlines established by the Brazilian judiciary, which they were already breaking the convention in that case. And we're not applying the convention as Brazil adopted it. That was already something that was broken by the American judiciary. Do you want to add to that, Renata? Well, yes. I'd just like to reinforce this. I'm in agreement with everything that Fabio mentioned. I think that, well, we have Article 12 in the protocol, which foresees cooperation of the Brazilian courts and foreign courts in relation to insolvency, which should be effective in this topic. And I'd also like to highlight that for those of you who don't know, at the end, the 30-day deadline was not observed, but in the end, the São Paulo Justice Court, led by the Judge Ricardo Negrão, approved this measure at the end of 30 days. So it's a pretty long deadline. And I talk to Ken sometimes, and we say it wasn't a result that's that different at the end of the day. So these notifications that were offered in the bankruptcy law 14,112, they're very recent. I particularly didn't see any cases that was started after the change in the bankruptcy law. I know that some existed. I know that some relevant ones are mentioned yesterday, but with the with the new part entering into execution in relation to international insolvency, we think the problem will be milder in cases relating to this law and for the execution of the CTC as well. I think that's basically it. Well, thank you very much. I also share the points of view that were mentioned by Dr. Fabio and Dr. Renata. What really catches my attention in this perspective of international law and internal law is this normative plurality, because we have different legislations. We have ancestral legislating. We have the model law of 1997, and we have national laws that talk about insolvency. And then we need to think about ways to coordinate the main goal, even in cases of bankruptcy. I'm not an expert in the area, but really, what really catches my attention is that Ken mentioned that there are no exclusive jurisdictions for many topics. So if there's a point of connection that connects jurisdictions, this can be brought to that jurisdiction, and this is a right of the involved parts, so that companies can seek out the best solution based on the principle that they seek, which is the principle of maintaining the company, continuing the company. At the same time, they also have a commitment that is both creditors and debtors have the CTC commitment of guaranteeing international property, which was insured at Idera by the debtor of recovery of mobile equipment, aircraft, and so We need to seek out a solution for the main goal, and I think that CTC brought this, which is innovative for international law, which is not only recognizing international property as registered by the RAB, but also the recovery of these assets according to the CTC. And so the recognition of the right to property in an international law that was only in the beginning of the early 20th century, have around 100 years in the recognition of private property in the international level. And so the Aeronautical Registry did great work in guaranteeing the the right to property and also safeguarding this right to property and bringing safety and visibility and bringing lower interest to credits and investments so that we can keep this industry going well.
Thank you very much. As I mentioned before, I don't work with insolvency on a daily basis, okay? So my participation here now is a little more related to the knowledge I have, the little knowledge I have from the academic perspective and from the private sector. Insolvency from an international perspective, and I'm using insolvency to encompass everything. We have a Brazilian model nowadays of the bankruptcy, which is liquidating all of the assets of a company and closing up the company. And we also have the legal recovery of the company, and we're trying to sustain that company's activity. When we analyze this context to the airline companies or the airliners, and the users of these assets that we are discussing within the CTC, we notice that intervening in that production asset, which is the aircraft, the helicopter, or the engine, which means closing down the company and shutting down the operation. So we have to deal with this duality. And the second perspective, classically speaking, when it comes to private international law, these insolvency instruments, they're essentially territorial. What do I mean by that? Each one of the sovereign states within their political influence arenas, within their legal influence arenas, they are going to deal with these things. What do I mean by that? The assets or the property of a legal entity, the property of a legal entity that is inside that jurisdiction, inside that territory, is going to be subjected to the rules of that territory. So we're going to have a large company, such as the airline companies. We're going to have contact points or reference points when it comes to the property. One aircraft is going to fly from one country to the other, and then at a magical moment that they decide to file for insolvency, the assets or the properties are all over the world. And what now? And so the property is all over the world in several territories. So how can we overcome this problem? So the amendment that was mentioned, it's pretty recent. It talks about a cooperation idea between the several jurisdictions regarding the insolvent entity. In Brazil, we have this deconnection or disconnection. And so this is a first problem when we're talking about this problem, when we're talking about airline companies. And a second point that we have, the chapter that was introduced in the law number 11,101. Let me try to find the best term for that. Speaks about cooperation. Cooperation in the following sense. Let's sit down and chat. Let's coordinate to all the extent possible, and the possible is limited by factual things. Where is the property? How can I preserve it? And it's also related to the legal limitations. And we have already discussed the legal limitations, the sentences, etc., etc., etc. So the main issue, in my understanding, is what is the limit? And I always think about this when I discuss this. And Dr. Renata and Dr. Yezi mentioned that. When did this chapter come into effect? The beginning of the chapter, recognition for the foreign sentences or decisions that are international. And please allow me to say that that's not that. I believe that the word was badly used by the legislator, and that was also the opinion of Dr. Nereida at that time. So the possibility of a national judge that is facing bankruptcy or insolvency lawsuit, he has to raise his eyes, look up, and to see what's happening abroad, what's happening at the international scenario. But we are not at the moment to effectively coordinate the procedures in a way that we can extend, expand automatically or quickly the limitation orders, protect them, not protect them, etc. But I believe, but I like the idea of the place where the property is located, preserve that jurisdiction or that forum. But the assets, they move from one place to the other. What the heck? Yes. So we still have 3 minutes, and I would like to summarize some ideas that arose during our conversation, and I believe that our conversation was wonderful, and we are always trying hard to improve the compliance index. We are always trying to improve the compliance index. So since 2019, we have been discussing the possibility of the declarations, but I'm not an expert on civil procedural law. But I believe that that's not easy to do in Brazil. And the experts, they have been sharing that idea with me. But we have the idea of the possibility of using ways to facilitate the communication between the nations, the countries, regarding the RAB, the International Registry, and maybe this could be done and this could be well accepted abroad. And so we would be able to comply better with the convention. And we could also establish Brazil has always been ahead of many countries when it comes to compliance, mainly with IDERA. IDERA is not the main topic of our panel, but just to let you know, I believe that Brazil has honored more IDERAs than any other country. And so if it's not the first, it's one of the first. And this is acknowledged abroad. And I believe that in the judicial area, we can maybe lead in other areas, and we should improve the communication between the countries. This is an idea that arose here during our conversation. The idea about a specific law, a specific procedural law, this would be outstanding. And so, unfortunately, you're not the dictator that you wanted to be, and you cannot do that. But as Mr. Fabio mentioned, you would have my vote, you would get my vote. And I believe that it was interesting to hear that there are other fields, other areas not related to the air sector in which there was an exemption of the entire exemption process, and that was done by the STJ. And that is a wonderful example. We should think about this. How can we adjust this exemption and we can use these procedures in Brazil? I believe that all of these things could help us out in this effort that is being carried out by ANAC and by other stakeholders. And we should not only think about the index, not only to comply with the law, but to have this extra beyond the index. So, would all of you like to say a few final remarks before we wrap up? And so I'm using the microphone first. Thank you, Anaki. Thank you for the honor of this invitation. It was a great honor and pleasure to be with you, and I'm at your disposal. Thank you so much. It was a very interesting panel. And as a professor, we always think about the compared law so that we can comply with a 10-day deadline and discuss this with other nations. And this would be very, very interesting to get to know more the cultural differences between our nations. Anaki, once again, thank you very much. And it was a great honor to be sitting here, okay, with all of you, all of my fellow panelists. Let's maintain in contact. Thank you, Dr. Marcelo Nardi. Thank you, Miss Renata. Thank you. I would also like to say thank you. Thank you for all of the teachings, okay? In 1 hour, I was able to think about things in a different way. Thank you very, very much. It was very fruitful. Any questions from the audience to the panelists, ladies and gentlemen? No questions? So thank you so much for your participation, ladies and gentlemen, on this morning panel, and also thank you to the moderator. Now we're going to have a 30-minute coffee break, okay? Thank you so much. Ladies and gentlemen, please take your seats once again and switch off your cell phones or put them on the silent mode. And now, a case study. Issues raised by the case of the Go Air Company in India. And we already here have with us Mr. Jeffrey Wool. Muito obrigada a todos. Eu sei que a maioria dos palestrantes usaram um microfone, ficaram sentados, mas eu gosto de falar daqui desse pódio, né? E isso fala um pouquinho da minha megalomania, né? Então, pensem nisso. Então, eu tenho 15 minutinhos agora. Eu poderia falar sobre esse tema durante 50 minutos ou 50 horas. Mas seria um tempo super bem gasto em relação à CTC, né? A Convenção da Cidade do Cabo. Nós já conversamos sobre a compliance com esse tratado, respeitá-lo. E quando eu digo compliance, eu falo aqui os governos, todos os setores governamentais, as autoridades, o judiciário, eles todos aplicando em casos práticos a Convenção da Cidade do Cabo, ou a CTC, de acordo com seus termos, cláusulas, com a sua correta interpretação, baseado naqueles especialistas da interpretação, como ela foi melhor interpretada. E esse é o assunto. E quando a gente usa a palavra compliance o tempo todo, eu quero que vocês entendam essa palavra completamente ao discutirmos essa palavra. Então, o termo é ou na prática, ou nos tribunais, ou as autoridades deveriam aplicar os termos e as cláusulas da convenção ou interpretá-la da forma correta, de acordo com todo o entendimento dos maiores especialistas sobre a sua interpretação. E ontem surgiram problemas ou questões que foram identificados ao redor do mundo e o Brasil especialmente sobre a compliance com a CTC e o AWG, que é o Grupo de Trabalho da Aviação, precisamente, cuidadosamente, ele descreve e lista e analisou todos os problemas. O que eu quero fazer hoje com vocês, parcialmente, é um problema de compliance em um outro país. Nada é comparável ao Brasil. Tudo no Brasil é o maior, é o maior, é o maior estádio, nada se compara ao Brasil. Mas a Índia tem algumas coisas semelhantes ou alguns paralelos, digamos assim. Não é tão grande quanto o Brasil, mas trata-se de um caso extremamente importante. E eu queria fazer isso no contexto de descrevermos o que aconteceu e comparar isso às coisas que já aconteceram no Brasil. Então, isso pode ser feito através de uma analogia, e há muitos paralelos que podem ser tecidos aqui nesse caso. E nós chamamos a falência da empresa aérea Go Air. Go Air. E é um caso muito interessante. É como se fosse o zero, o início, o marco inicial da compliance com a CTC, a Convenção da Cidade do Cabo. Então, vou discutir um pouquinho mais sobre compliance com vocês. Depois, eu vou falar para vocês o que aconteceu com a Go Air e vamos chegar às conclusões. Ok? Mas então, vamos começar com o seguinte. Esse gráfico aqui, ou esse slide, nós produzimos esse slide há muito tempo atrás. E ele evoluiu de diferentes formas e ele venceu a prova do tempo, ele usa diferentes palavras para descrever certas coisas, mas tudo bem, a gente pode usar essas palavras ou outras. Mas esse slide, ou esse arcabouço aqui, é bem bom. Então, ele discute problemas de compliance, quais seriam esses problemas de compliance, e outra forma de encarar esse slide seria um pouco mais severo. Ele é um pouquinho mais light. Quando a gente fala de compliance, eu só dei o resultado final. E será que o tratado será aplicado de forma precisa? Então, subdividindo isso em relação aos seus componentes, e vamos fazer essa pergunta a nós mesmos, no Brasil ou na Índia, onde que essas razões se aplicam? Então, a primeira fonte de falta de compliance é a implementação da falta de compliance. Bem no início, o tratado não foi implementado de acordo com a legislação nacional. Os tratados são estabelecidos, temos obrigações internacionais e são discutidos, determinados, regulamentados, aplicados de acordo com os princípios da lei internacional ou do direito internacional, mas a forma como o tratado se aplica em relação à legislação nacional, trata-se de uma questão nacional. Depende do sistema nacional e muitos países são impactados diretamente por isso, são necessárias outras ações. Em outros países, o tratado tem que ser transformado ou incorporado à legislação nacional para ele ter um status de lei. Em outros casos, ele fica subordinado a menos que haja uma razão para ele prevalecer, por exemplo, uma cláusula específica ou as regras do Brasil são mais específicas, questões de governança. E eu deveria dizer o seguinte, como uma observação: uma das maiores fontes de aplicação da CTC acontece mais tarde, com o passar do tempo, e é mais específica. Com o passar do tempo, ela pode ser sobrepujada por um instrumento melhor e maior, mas a gente tem que tomar cuidado com o seguinte: será que não seja muito mais tarde, ou uma coisa que seja muito mais específica? Não vou falar mais sobre isso, mas a pergunta do limiar é o seguinte: o tratado foi implementado corretamente no seu país? E nós tivemos alguns problemas aqui no Brasil para que pudéssemos alcançar a posição que estamos agora. Mas a perspectiva estabelecida é que a implementação aqui no Brasil foi muito, muito forte. A única lacuna que eu já mencionei ontem foram as exportações. Parece que as regras não parecem ser abrangentes o suficiente em termos de exportação. E quando um terceiro tenta exportar, dadas as leis vigentes e as práticas vigentes. Então, o lado da implementação foi bom. Então, há dois aspectos dessa implementação. Será que ela tem prioridade legal? E o sistema é suficiente, completo e informativo para que os juízes e as autoridades possam de fato chegar a conclusões corretas? E o exemplo mais fácil que a gente gosta de dar, suponhamos que você tem um país, e há muitos países onde o tratado automaticamente se aplica ou é aplicado e tem prioridade sobre leis conflitantes, e isso acontece em muitos países. Mas não há regulação da aviação civil que não fala para uma autoridade o que fazer. Então, teoricamente, a lei tem primazia, mas uma questão prática é que a autoridade, analisando o caso, não tem os materiais e os instrumentos necessários para seguir o que é necessário, baseado naquela sua constituição ou legislação. Então, eu acho que nesse momento aí o Brasil está bem, mas a Índia não tanto. E aí depois a gente chega às categorias 2 e 3, e isso aqui bem cru, mas vai te dar uma ideia boa. Então, na questão de compliance aqui, eu vou falar, bem, a lei deveria ser aplicada corretamente, em questão de legislação nacional. Ela foi implementada corretamente, mas a questão agora é, de fato, de fato, ela está sendo feita assim pelos tribunais e pelas autoridades? E aí, essa é uma pergunta fatual. E há muitas razões pelas quais a resposta pode ser não. Então, falando nua e cruamente, eu coloquei em duas caixinhas. Uma seria uma não compliance não intencional e uma não compliance intencional. A não compliance não intencional é esse caso. A autoridade de aviação civil não tem regulações ou regulamentos suficientes, embora, de acordo com a Constituição, isso deveria ter sido feito. Ou um tribunal não está ciente de alguma regra por causa de uma alegação de um terceiro pessoa, e aí todo o judiciário, eles deveriam conhecer todas as leis, mas isso não acontece no mundo real. E às vezes, se os advogados não argumentarem o caso corretamente, então é ficção que o juiz sabe tudo de tudo. Então há uma non-compliance não intencional. Se o juiz ou a autoridade tivesse as informações corretas, eles chegariam à conclusão correta com o passar do tempo.
Temos muitas razões por que isso poderia acontecer, dependendo do nível de perícia das partes, a falta de informação, nem todos os juízes sabem tudo sobre relações de tratado. Se a gente vê as conversas que nós tivemos aqui, e um dos palestrantes mais cedo falou, temos uma constelação de regras que aplicam em relação à insolvência internacional. Isso é um material muito complicado. E não podemos esperar que um juiz de uma corte estadual jovem saiba sobre as leis de tratado internacional. Em teoria era para eles saberem, mas na prática nem sempre. E temos também erros que são feitos com as melhores intenções. Mas depois de passarmos por esses fatores, temos outras coisas que reforçam esses erros. Aqui eu chamo eles de aspectos institucionais. Então, em um número de sistemas judiciários, inclusive na Índia, talvez no Brasil, o judiciário está sobrecarregado e não tem o tempo para realmente atender as demandas dos casos, com todos os seus prazos, ouvir todas as partes no caso. Temos uma ideia muito fantástica em relação à lei de procedimento, porque sem isso nós temos limites institucionais que previnem, apesar das melhores intenções, esse compliance, essa conformidade. E isso se aplica tanto da perspectiva administrativa quanto judicial. E aí entramos numa categoria mais difícil, que aqui eu chamei de não conformidade intencional. Bem, isso quase nunca é descrito como uma não conformidade intencional, mas nós temos o protecionismo. Sim, tem aquele tipo legal. Eu sei que a lei é clara. O Brasil passou 14 anos discutindo aquilo. Bem, eu não quero que esse seja o caso. Essa é uma não conformidade intencional. O juiz não fala isso abertamente, mas a gente pode dar até o crédito ao juiz. Não houve nada com o segredo. Não era um segredo. Eu sei que a lei do CTC é essa, mas. Então eu aprecio a honestidade dele. Ele falou abertamente, na verdade. Então, tem certas proteções desse sistema baseado em políticas. E quando a gente vai mais longe, na, numa direção ruim, nós temos, por exemplo, a Rússia no contexto da CTC e outros tratados ultimamente, basicamente ignorando as regras e as leis por uma razão ou outra. Então, isso não é limitado à Convenção da Cidade do Cabo. Isso acontece com vários tratados internacionais. Então, mantenham isso aí na sua mente enquanto a gente olha o compliance de forma holística e vamos usar esse tipo de abordagem para fazê-lo. E com isso, como contexto, vamos discutir o que aconteceu com a GoAir. E é um caso muito interessante para discutir o que aconteceu e se perguntar o que aconteceria no Brasil aqui nesse caso. Temos diferenças, porque as leis são diferentes, mas talvez seja um experimento intelectual aqui. O que aconteceu na situação do GoAir, e eu já vou falar aqui, nós na IWG estamos analisando muito cuidadosamente. Muitos dos nossos membros tinham suas relações com a GoAir, e um dos nossos membros é a Pratt Whitney, que está envolvida nessa disputa comercial. Então a gente não vai tomar nenhuma posição nessa situação específica, a gente vai falar mais de forma mais geral. Então, a GoAir ou a Go First é uma linha aérea de tamanho médio, mas muito bem conectada politicamente falando, e ela teve uma série de problemas ao longo do último ano. Alguns desses problemas são relacionados a problemas comerciais que teve com a Pratt Whitney, que é uma indústria de motores. E bem, eu vou dizer que tem uma boa razão. Eles dizem que tem uma boa razão para não estar fornecendo esses motores, mas por uma razão ou outra, a linha aérea não conseguiu realmente pagar as suas obrigações financeiras. Então, os credores começaram a dar cartas dizendo os problemas. Não houve nunca nenhum tipo a- de controvérsia em relação a isso, porque elas estavam realmente indo à falência. E temos esforços que foram feitos para reestruturar os pagamentos, atrasar os pagamentos, e isso aconteceu durante mais ou menos 6 meses. Eles reservaram seus direitos, mas não terminaram as- os arrendamentos. No dia 2 de maio, a GoAir aplicou para iniciar os seus procedimentos de insolvência dentro de um novo código de falência que começou a ser executado há 3 anos na Índia, mas que nunca tinha sido utilizado no contexto da aviação, em que uma linha aérea estava tentando se reorganizar, nunca tinha sido utilizado. E então eles fizeram uma petição de insolvência e a proteção da organização. E na lei indiana, a petição para entrar em falência tinha que ser aprovada pela corte. Então tínhamos um período de gap, uma lacuna entre a data que houve essa aplicação e a data em que a corte aceitou essa petição de falência. Em muitos países, quando você tem esse período de lacuna, naquele momento, quando a corte aceita, as regras aplicam retroativamente. Ou seja, se nós temos um moratório, qualquer coisa que aconteceu nesse período lacunar vai estar inválido. Em outros lugares, como nos Estados Unidos, a aplicação em si automaticamente começa esse moratório. Mas na Índia não aconteceu isso. Esse período de lacuna em que a lei a lei normal sem ser de falência aplicava até a falência. Aí os credores terminaram seus arrendamentos imediatamente quando eles entraram em falência. Então, o que você pode dizer quando você ouve isso? Bem, isso é errado, isso não é justo. Isso não é moral. Eles não deviam ter feito isso. Ou você pode dizer, eles tinham todo o direito legal de fazer isso. Eles estavam seguindo as regras do país, eles sabiam que tinham aquele direito, eles esperaram até o final, eles tentaram conciliar as coisas até o último minuto e no final eles exerceram seus direitos legais. Então, então a gente tem esse contínuo entre a lei dura até algo que já vai mais para moral, ética e não uma lei. Então, a corte aceitou a aplicação, a petição de falência para prosseguir, então, no caso. E o tribunal, esse é um novo tribunal de insolvência que foi criado pela nova lei, que é muito pró-reorganização. Seu propósito é reabilitar os devedores. É um ambiente muito pró-devedor. E o tribunal disse: ok, nós aceitamos a sua petição e agora nós temos essa moratória. Ninguém pode tomar ações contra a linha aérea ou seus ativos, dada a decisão do Tribunal de Falência, e temos um período de 6 meses que pode ser estendido por 3 meses, 2 vezes, o que é que a lei de falência indiana fala. Então, a Índia ratificou a Convenção da Cidade do Cabo e eles declararam um período de 60 dias, que é muito menos do que 6 meses, ou 9 meses, ou 12 meses. E além disso, acontece de forma similar com o Brasil, a Índia tem uma regra que, bem, a maior parte dos advogados pensa que essa é a regra, em que se um arrendamento é terminado antes do início da falência, a linha aérea não tem mais esses direitos, ela não tem mais direito a todos esses ativos na falência. Ou seja, isso está fora dos procedimentos da falência. O efeito dessa regra, qual seria o efeito da regra? É aqui que a gente estava falando no Brasil, o efeito dessa regra, então, é que basicamente todas as aeronaves que estavam sob arrendamento não estariam mais sob sua posse, e a Convenção da Cidade de Cabo diz que as aeronaves devem ser retornadas até 60 dias, no caso da Índia, 30 dias no caso do Brasil. Nós temos também a lei internacional Gate, em que o devedor não tem mais os direitos de posse. O que quer dizer, os direitos da Índia falam que é imediatamente. No Brasil também muitos argumentam que é imediatamente. E era isso que estava acontecendo. E o sistema que a gente já ouviu bastante sobre ele. Bem, ouvimos bastante coisa aqui hoje sobre os tribunais brasileiros e os aspectos complicados. Esse não é o único país do mundo que tem um sistema complicado. A Índia tem um sistema muito complicado, tanto de fato que todos os credores fizeram processos no mesmo caso e na mesma questão por causa de alguma regra ambígua, de tal forma que se eles não fizessem esse processo, eles não se beneficiariam de uma decisão genérica judicial. Talvez tenha um alto interesse aí envolvido, né? Mas nós temos mais ou menos 30 processos acontecendo ao mesmo tempo, basicamente sobre a mesma questão, e isso continua agora. Então, a gente vê essa gama de coisas e de forma processual as coisas, houve um apelo dentro da. Você tem essa corte de recurso acima. E, alternativamente, você pode fazer uma ação no sistema dos tribunais superiores, em que você também tem você tem o Tribunal Superior, você tem todas essas instâncias, e aí eles queriam desregistrar as aeronaves por meio das IDERAs, e eles falaram, nós estamos congelados. Né? Como aconteceu na Avianca, eles falaram, bem, nós temos uma ordem judicial dizendo que há uma moratória, e o arrendador falou, isso está incorreto, legalmente falando, porque a linha aérea não tem mais direito sobre as aeronaves. Então eles foram para um tribunal que não é um tribunal de falência, que seria menos pró-devedor. Então isso tudo foi litigado e ao mesmo tempo, nesse período de tempo, enquanto a convenção da Cidade do Cabo está passando e dados os procedimentos civis na Índia, a Índia também fez esse prazo de 10 dias, mas agora nós estamos na falência, então o único prazo que a gente tem que discutir é o de 60 dias, não os prazos judiciais. Então, o mecanismo do sistema automaticamente iria além de 60 dias. Então, se a gente voltar para a minha tabela anterior, realmente tínhamos aspectos institucionais da lei processual que levaram à não conformidade, pelo menos em relação ao número de dias. Então, nós temos recursos, litígios acontecendo em vários níveis, em vários tribunais ao mesmo tempo, todos conectados ao escopo da moratória, à relação entre o período de espera e a lei nacional, que necessitava da repossessão imediata e de acordo com muitos dos advogados dos arrendadores e a linha aérea, bem, nós temos o praticante de administração, vamos chamar ele só de administrador. E o administrador, bem, eu estava falando aqui com um colega sobre uma questão similar aqui no Brasil. O administrador está tomando a posição. Bem, eu sei que se você me forçar a falar isso, eu sei que a regra é X, que a aeronave voltaria, mas a motivação dos credores aqui está errada. Eles tomaram essa ação somente porque a gente vai fazer a falência. Por causa disso, o tribunal, utilizando seus poderes de equidade, o que eles não têm na Convenção da Cidade do Cabo, porque é um sistema baseado em regras, você, o seu tribunal de falência o seu juiz deve ser sábio, tal qual Salomão, mesmo que isso seja banido pela Convenção da Cidade do Cabo, que é um sistema baseado em regras, é, que está lá para você ter mais habilidades para monitorar o financiamento, para reduzir custos. Então, ele botou de forma muito gentil, falando: quando estamos olhando questões como essas no desenho dos tratados, nós podemos falar, você vai equilibrar o tratado para um nível X de antiprevisibilidade, ou você calcula o risco, ou você não se preocupa com isso e você quer uma quantidade X de justiça. Só o que importa é que a coisa certa seja feita. Claro, um dos problemas é que a coisa certa depende no que aquele juiz específico acha que é a coisa certa naquele momento. Então, ao menos que você tenha um critério objetivo do que está certo e não certo, são questões. A gente está falando sobre lei comercial aqui, a gente não está falando. Bem, novamente, esse é um ponto muito importante de se entender. Nas diferentes áreas da lei, essa escala vai ser muito diferente. Você pode tentar equilibrar as coisas muito mais para uma equidade, uma justiça ex post. Por exemplo, quando você está lidando com lei da família, direito da família, é um caso, mas e para o direito comercial, em que as pessoas estão tomando decisões de investimento. Isso é bem entendido. E a convenção da Cidade do Cabo é o epítome, é o ápice. Então foi algo que foi desenhado para rastrear bilhões de dólares de financiamento em uma área muito arriscada, em que ativos estão se movimentando. Então aqui nós temos o ápice realmente do caso em que a previsibilidade e a clareza e a certeza ex ante deve estar acima da imparcialidade ou da justiça ex post, que, de acordo com o pensamento de um juiz. Então, na forma como as coisas evoluíram e a forma como as linhas aéreas fizeram sua arguição, o novo sistema de falência está aí para nos ajudar a reorganizar, para salvar os trabalhos, as receitas de impostos, são coisas muito importantes, mas todo mundo já sabia disso no começo, todo mundo já sabia e a Índia sabia disso quando eles ratificaram o tratado. É um, é um equilíbrio que você tem. Então, será que o país deveria ter ratificado o país ou não? Bem, eles já ratificaram. Agora a gente está falando sobre conformidade, sobre compliance. Os juízes não são legisladores.
Então, embora eles sejam muito sábios, eles não são legisladores. As pessoas já tomaram a decisão. Então, esse é o tipo de questão que está sendo discutido no cerne dessas questões. Então, isso é uma fonte principal de problemas que nós percebemos. Outra fonte que não se aplica aqui é a Índia não passou uma legislação de que tem primazia. Sob a Constituição indiana, o tratado é subordinado a atos legislativos posteriores. E o Código de Falências indiano, ele ocorreu mais tarde no tempo, e ele tem uma cláusula de primazia que diz o seguinte: as regras do Código de Falência se aplicam com prioridade sobre qualquer lei conflitante ou instrumento conflitante. E nós já vimos isso antes, né? Há um caso interessante quando você tem duas cláusulas que têm primazia, nós realmente temos a primazia. Então, depois que a CTC é aprovada, então você vai ter duas leis que são primárias ou que têm primazia. Então teremos que ser mais específicos. Mas a Índia não aprovou uma legislação que tem primazia, uma primária, mas eles aprovaram regulações ligadas à aviação civil, que complementavam a CTC, a Convenção da Cidade do Cabo. E a convenção foi aplicada precisamente no caso do IDERA e do registro do IDERA, porque eles tinham implementado o registro e também regras de exportação nessas regulamentações, mas eles não lidaram com a convenção como um todo. E em relação à questão de falência, quando alguns casos surgiram na Índia, fora dessa lei de falência, embora não houvesse nenhuma legislação específica ainda, os tribunais tentaram. E eu vi muito disso nos últimos dois dias. Quase todos os sistemas legais do mundo, eles têm um conceito que parece que soa melhor do que é. E o conceito é algo assim: construção harmoniosa. Todo mundo tenta harmonizar tudo. E por que não? Você tem várias coisas diferentes que parecem dizer coisas diferentes e você tenta uni-las de uma forma que elas se tornem compatíveis, consistentes, e às vezes você consegue fazer isso e às vezes não. Então, o Tribunal da Índia, não temos uma legislação, mas a gente tem esse conceito de construção harmoniosa. E nós observamos que nós temos uma obrigação com o direito internacional, como mencionado por duas pessoas ontem, o artigo 27 do Tratado de Viena, você não pode usar a lei nacional como uma defesa contra um tratado internacional que foi ratificado. Então, por essas duas razões, nós vamos tentar harmonizar o nosso Código de Procedimento Civil o mais próximo possível com a declaração que a Índia fez, que é a mesma declaração que o Brasil fez nas tabelas de tempo judiciais. E aí eles fizeram um trabalho muito, muito bom em relação a isso. Mas algumas coisas você não consegue harmonizar. Você não consegue harmonizar um período de 60 dias com um período de 90 dias. A harmonização não significa 5 meses. Você não pode fazer uma média ponderada. Então, há um certo conflito. Então, precisa haver uma regra superior a isso para fazer essa harmonização. E na Índia, agora, nós temos um período de 60 dias que é no dia 10 de julho. Então, no dia 10 de julho, independentemente de todo esse contencioso sobre a moratória, o escopo da moratória, no dia 10 de julho o período termina. E a Índia fez uma declaração explícita que no dia 10 de julho todas as aeronaves precisam ser retornadas ou as dívidas pagas. Então, os advogados agora estão numa posição extremamente delicada, o cliente também. Na verdade, todos estão numa posição muito delicada para saber quão fortemente devemos utilizar o argumento da CTC. Por um lado, as pessoas falam assim: eu não quero fazer o argumento baseado na convenção, porque eu vou perder, porque não há nenhuma primazia, não há nenhuma lei que tenha primazia que tenha sido aprovada. E o juiz do Tribunal Superior vai falar: eu tenho a obrigação do tratado, eu tenho a Constituição indiana, e ele vai falar isso contra a aplicação da convenção. Há uma outra perspectiva que diz: as coisas nunca são tão claras, há sempre questões políticas que interferem. Em relação à construção harmoniosa, se esse caso for feito dessa forma, os juízes não vão dizer, como o juiz da Avianca: olha, eu não quero violar o direito internacional, mas eu terei que fazer isso. É difícil falar isso. É difícil para um juiz falar isso. Ou então a Suprema Corte da Índia falar: eu vou quebrar o direito internacional. É difícil falar isso. Com todo mundo observando, pessoas como nós, o índice de compliance. Então, há um projeto de lei que está sendo analisado. E há questões políticas. Ele vai ser aprovado? Não vai ser aprovado? Quando? Então há uma grande comoção e eles acham que isso vai levar a que esse projeto de lei seja aprovado. Então, o grupo de trabalho, o AWG, emitiu uma notificação de negação ou de negatividade. O score deles com certeza irá ser reduzido se eles não implementarem a CTC. Nós não falamos com a mídia, tá? Mas 8 jornais na Índia mostraram essa queda no score. E isso foi feito de tal forma que diferentes pessoas queriam o perfil, queriam a pressão política disso para fazer com que o projeto de lei fosse aprovado. Trata-se de um mundo complicado, a falência de companhias aéreas é algo político. Então, eu ouvi sobre as falências aqui no Brasil e é sempre bom saber, gente, vocês não estão sozinhos. Isso é semelhante em outros países. São questões diferentes, mas não são tão diferentes, né? Eu achei que seria interessante vocês ouvirem isso. Então, eu não vou me delongar muito nos detalhes, nos vários casos, e quando eles poderão ocorrer ou não, mas isso mostra para você que essas mesmas questões existem em outros lugares. E na Índia, eles estão recebendo 600 aeronaves no futuro próximo, e as consequências financeiras disso são gigantescas, e todo mundo está ciente disso. Então temos que manter isso em mente. Eu passei por alguns slides, eu já discuti esses slides, mas esse slide simplesmente resume o que eu falei. E lembre-se que eu vou disponibilizar todos os meus PowerPoints para vocês. Então, tem o equivalente, tem que voltar a isso. E depois a questão de a prioridade em relação a uma falência. Você pode analisar os argumentos que foram feitos aqui. Até o terceiro parágrafo, sobre o administrador argumentando: então tem a natureza ipso facto, que as ações foram tomadas para evitar qualquer tipo de falência. Dei uma olhadinha nisso mais demoradamente em casa depois, tá? Já disse tudo isso, já disse tudo isso. Então agora eu vou passar para coisas que nós fizemos e estamos fazendo para tentar promover a compliance nesses casos. Vocês sabem as coisas que fazemos. Então, eu já vim ao Brasil e já 8 vezes para discutir a Convenção da Cidade do Cabo. Eu acho que eu já vim umas 15 vezes lá na Índia. Então, temos grandes e boas relações com todos vocês. Não diferente daqui, também temos um relacionamento muito, muito bom com a autoridade de aviação civil lá na Índia. E principalmente agora eles têm um tribunal específico de falência. Quando tudo isso aconteceu, sempre que há uma falência, a primeira coisa que a gente faz é ligar para os nossos advogados, amigos, e a gente tem várias pessoas aqui no auditório que são advogados e a gente tenta obter os fatos. O que que aconteceu? O que que aconteceu de fato? E a gente escreve uma carta para o juiz, ou para a autoridade de aviação civil, ou para a pessoa correta, dizendo: olha, essas são as exigências do tratado. E é claro que às vezes o juiz não vai seguir o tratado porque ele não conhece as exigências do tratado. Então, como serviço público, a gente manda isso. A Índia fez isso, esse é o comprometimento, esse é o compromisso, a linha de tempo é essa. A gente abre um canal de comunicação, a gente se comunica com o governo, a gente não conversa com a mídia, a gente é totalmente aberto e transparente sobre isso. Não é uma questão de opinião, é um formato preciso, objetivo. E nós fizemos isso, aí fizemos uma análise, e quando a moratória foi declarada, nós entramos em contato com o nosso grupo de contato, e como a pergunta do Brasil sobre a moratória, esse foi uma pergunta indireta à CTC. E a pergunta direta é: na lei indiana, a moratória se aplica? Então, os credores têm direito ao pagamento do leasing? Porque o artigo 11.2b, que a aeronave volta antes do período de espera. Então, se trata de uma pergunta da CTC, derivada de uma análise da lei local ou nacional. Então, no AWG, não somos qualificados a fazer uma análise da legislação local. Então, a gente pede para o nosso contrapartida na Índia fazer isso, mas nós pedimos consenso. Nós tentamos garantir que haja 9 advogados na Índia e solicitamos um consenso sobre a posição. E tomamos uma posição baseada no que eles falam para a gente. Chegamos à conclusão que a convenção não foi aplicada, respeitada. E aí tudo foi uma loucura quando a mídia anunciou isso. Então eu cumprimentei o grupo de contato do Fábio, mas eu vou repetir o elogio, tá? Ele é o presidente do grupo de contato. E nós ficamos enrolados nesse engajamento com a mídia. A gente teria preferido não fazer isso, mas isso simplesmente aconteceu. Às vezes você não consegue controlar essas coisas. E a gente emitiu uma notificação no nosso site. E eu vou discutir isso daqui a pouco com vocês. E continuou. Muitas pessoas no contencioso utilizaram os nossos documentos. E às vezes a gente submete resumos, documentos, alguns relatórios, alguns papers, e a gente faz isso regularmente. A gente não mexe com a lei nacional, a gente só analisa os tratados internacionais. Então, a gente já fez essas coisas, fizemos algumas coisas semelhantes a isso aqui no Brasil. Nós produzimos alguns papers no caso da Ocean Air, lá em Nova York. Então, a gente se engajou com a Ocean Air em Nova York e aqui no Brasil. Então, quais foram algumas lições aprendidas ou o que estamos aprendendo com esses casos? Me falaram assim, tome cuidado de falar a expressão lições aprendidas. E me pediram para colocar em parênteses, lições que estão sendo aprendidas. E quando você compara o caso da Índia ao Brasil, então você tem a falta de claridade, perdão, a falta de clareza sobre a primazia da CTC ou então o fato das regulações serem incompletas. Isso tem que ficar claro. Eu não. Então, é uma lição que a gente tem que lembrar, não uma lição aprendida. O segundo a questão da moratória. Isso é discutido em muitos países. Isso se aplica à Índia, ao Brasil. Então, isso é uma ideia recorrente. E os riscos são muito, muito altos nesse ponto da moratória. E as pessoas têm que dar um passo para trás e falar o que estamos de fato discutindo. A questão é. Eu não estou falando agora como representante do grupo de trabalho AWG. Eu estou falando de forma filosófica, acadêmica. Se você quer reorganizar uma linha aérea, uma companhia aérea de forma bem sucedida, então, você tem que se ficar engajado com eles, engajado até o último minuto, tentando resolver tudo. Não puxe o gatilho. Você quer que eles fiquem, renegociem até o último minuto para evitar problemas. Mas, se as consequências de esperar até o último minuto serão muito severas, aí eles têm o incentivo de agir mais precocemente. Então, há uma grande tensão entre como aderir à política e como isso é traduzido. Quão mais rapidamente eu deveria encerrar esse leasing? Será que eu vou até o último minuto? Será que eu faço isso mais cedo? Será que eu pulo do barco antes de todo mundo? E aí depois é uma corrida até o fundo do poço? Então, isso aqui não é nem para os juízes, isso aqui é para. Então, o sistema de falência, ele tem como objetivo reorganizar as empresas. Mas que incentivos são dados às partes para que elas tomem uma atitude um pouco mais tarde? E você tem essa questão aqui, uma terceira caixa, relacionamento com o Código de Procedimento Civil. E o último painel falou sobre isso, sobre a parte prática, como isso funciona. Então, eu estou voltando para o nosso novo ditador para que ele possa resolver todos os problemas. Então, é um problema genérico. Então, depois de resolvermos isso, eu quero que ele seja o ditador do mundo inteiro e que ele crie uma lei final. E a última questão que eu gostaria de mencionar, não sei, acho que a gente não teve muito disso no Brasil. Mas uma coisa para a gente pensar no nosso setor e que piora a situação o atraso é mais do que simplesmente não receber o dinheiro. As aeronaves são muito valiosas e o seu valor pode diminuir rapidamente, deteriorar rapidamente. Por exemplo, se você tirar a fuselagem, tirar o motor, então a ideia do leasing é que o valor do bem ele diminui a perda, mas o valor da aeronave ele cai. Então, por exemplo, na Rússia, elas foram tomadas. E aí, a, as modernidades do contrato de leasing se perdem quando isso acontece. E ontem, na Índia, os tribunais se recusaram a dar proteção de fato em relação aos bens, porque isso não estava de acordo com as leis nacionais.
Então, nós temos aqui o índice de compliance. Nós queremos continuar a trabalhar em atualizar o score aqui, tomando essas ações conjuntamente de uma forma informada. Eu acho que tudo que eu ouvi no último dia e meio, eu espero que isso tenha contribuído de uma forma pequena, está focado nessa ideia de tomar uma abordagem informada e sofisticada em relação a essas questões legais e econômicas complexas, porque eu tenho certeza que as decisões certas serão tomadas com o máximo de informação possível. Então, fazer uma ligação entre Fábio e nós, a WG, eles podem ser lideranças e dar conselhos para a ANAC, que é um grande, são grandes líderes na região. Muito obrigado. Any questions? Any questions? The microphone will come to you if you raise your hand. If we have no questions, muito obrigado, Sr. Jeffrey. For the last theme of the day that will deal with international treaties and the Brazilian framework, challenges for effectivation, harmonization mechanisms, and compliance mechanisms, we'd like to invite to the stage the professor of the University of Brasilia, Professor Inês Lopes Matos Carneiro de Farias. The stage is yours, professors. The stage is yours, professor. Good morning, everyone. Once again, I'm back here again for the last panel, and I have the responsibility of closing this wonderful session organized by ANAC. I'd like to once again thank ANAC for the initiative and for the continuity of her works, and also like to thank you for the honor of being invited here to, and also to meet new people, new contacts for new studies, and also to meet some of my good friends. Sorry, we've had a few technical problems. I ended up sending two files, one a PDF and a PowerPoint file. Anyway, this is the structure of my presentation. First, I'd like to bring some definitions that I consider to be important about the treaty, legal framework, harmonization, and compliance. So it's an overview. I'm going to talk about the conflicts between national and international law, if there are conflicts, compliance and interpretation of treaties according to Brazilian law and international law, and briefly to speak about the international treaty, specifically the Cape Town Convention and the Protocol for Internalization, and the issue of private international law together with these international instruments, and finally to talk about harmonization through compliance. As has already been mentioned a few times, and I'd like to say once again, a little repeatedly, I'd like to bring the definition or the Vienna Convention of treaties. This convention was adopted in 1969, but as you've seen, Brazil only internalized this effectively in 2009, be it through the legislative decree, bringing attention to National Congress, and the decree that came in 2009. It This convention has 163 participants, so we have over two-thirds of the state's communities participating in this convention. And so a treaty in that convention is an international agreement that was concluded in writing by states and which is ruled by international law. So this concept is a part of the Brazilian legal framework, and it leads to reciprocal rights and obligations. And let's look a little bit further into legal law. The legal framework goes beyond regulating people's behaviors, but also regulates the way in which we produce these norms. And so it's important to highlight the work of Roberto Bobbio talking about the reception of norms, obligations, etc. And I'd like to talk about the autonomy and the will of the parts because the Cape Town Convention highlights quite a bit this autonomy of the parts, and it brings the idea of a power that is abrogated by the state. And it's also the recognition of the state of the autonomy of the parts about what we've called available property rights, for instance, in a specific law. In relation to ordinary laws, they end up being executed in the constitution of its states, also in the perspective of Norberto Bobbio. And we have the ordinary laws, which should produce behaviors in conformity with the legal language. And we have legal production, especially legal execution. How does the Brazilian legal framework work in the federal constitution? Article 59 talks about the legislative process. So we have constitutional amendments, complementary laws, ordinary laws, delegated laws, provisional measures, legislative decrees, and resolutions. Where are international laws placed in our constitution? If we think it's a legislative decree, it will be in item 6. So it's a gap that we have in the Brazilian legal framework because conventions, well, the federal constitution doesn't place the treaties clearly. When we're talking about harmonization with international law, this happens through international negotiations for treaties and intergovernmental negotiations, and this ends up with the recognition of bilateral or multilateral treaties like Hydro A or regional treaties like Mercosur or the OAS. And the goal is to increase the degree of legal safety and the foreseeability and predictability of certain legal relations. And so there's a need of harmonization, but still respecting the legal diversity and about the legal aspects of each state. We also have compliance, of course. I'm here with Professor Jeffrey Wool, who is a huge authority and who has really given us a lot of good things to think about in relation to compliance. But in relation to compliance, I'd like to say that laws, rules, establish standards of behavior in people, be they individuals or legal entities, should act in conformity. And these multi level agreements are regulated by international institutions. But I'd like to bring a counsel from PNUMA when he says the measures to not answer to compliance are part of a mechanism for compliance. So we're going to analyze not only whether you're complying to a treaty, but you're also going to identify the measures for not not complying to a treaty. So let's get into international law and national law and if we have conflicts. So, as we've seen in Article 59 of the Federal Constitution, there's no specific device in Article 59 for for international treaties in those norms, but we have Article 4 of the international law saying that Brazil is ruled by the principles of international laws, and we have, for instance, Article 5 that talks about human rights and in the tributary law as well. But we don't have other issues in relation to this. For instance, Argentina, our neighbor, their constitution in Article 75 says treaties and agreements have hierarchy above law, and integration law also has a hierarchy on top above laws. So they inserted into their constitution the position of international treaties in relation to their own laws. And we have other discussions. There are many other theories and professors that deal with this topic, but we're still discussing this issue of monism and dualism. And Professor Guido Fernando Silva Soares always used to say, in his last book, he says that these are 19th century theories or early 20th century theories that we've overcome for a long time, and we need to really rethink these concepts because the issue is, as he very positively said it, themes today are no longer local, they're global, but actions are local. We need to act locally, thinking about global commitments and problems that might be created. So really need to rethink this doctrine, review this doctrine, and I'd like to say what is the position of the STF, the Federal Supreme Court of International Treaties. So why the Supreme Court? Well, due to these gaps in our Constitution and in previous constitutions, the Supreme Court started to quote unquote legislate on international treaties based on decisions that were developed throughout time. And so in 1977, we had an international extraordinary appeals saying that there's normative parity with international treaties. This is the idea that international treaty are in the same level of ordinary laws. And so, where are treaties that deal with themes of complementary laws? So they will never be adopted, or they will have internal conflicts because this is not clear. They were put in a position, technically speaking, in this idea of a pyramid that they are below complementary law. And there's also, in this concrete case, due to a uniform law, you can see that we had a uniform law in relation to cashing checks. Well, checks in Brazil, no one uses them anymore, but they were the same as in Japan, for instance. And we said that it was possible to have a national law to revoke an international treaty on the principle of the puts later law surpasses earlier laws. And so in 2008, 2009, in relation of human rights, there was a position saying that people could be arrested due to debt, and so the international treaties were considered to be super legal entities. But the Supreme Court doesn't. There's a gap in relation to what about treaties that came before Brazil signed this. And so we have a temporal gap in that issue as well. And this led to a binding opinion in relation to being arrested due to debt. And what's fundamental about this? This is based on the Inter-American Human Rights Convention and the Brazilian Constitution. This was the Inter-American law was passed in the late 60s, but was only adopted in Brazil in 1992. And here we have the theme of civil aviation. We have an extraordinary appeal 660,631 that has to do with theme 210 about the limitation in relation to lost baggage. And it was understood, well, that the Warsaw and Montreal conventions have prevalence over the consumer rights laws, but the theme 1210, this was in 2022, 15th of May 2022, but which was published in March the 3rd, 2023, that the Warsaw and Montreal conventions do not apply to hypotheses of contract of air transport in relation to moral damages or extra property damage. So something that seemed like it was solved wasn't exactly solved. So the judiciary system, when it's working with certain themes that are completely different, it can lead to these legal imbroglios. And so, in relation to the Montreal Convention, I'd just like to point out that the convention has its own limits of responsibilities, saying that this is also an internal norm. And what is this comparison of this prerogative order? And we still don't solve this issue. And Article 55 also brings relationships with other instruments, saying that the convention will prevail over every rule that is applied to air transportation, and the Montreal Convention ends up also overcoming the 1929 convention from before. And now we come back to the Vienna Convention on the right of law of treaties that have to some general rules of the obligation of states in relation to international institutions, which were already mentioned both yesterday and today. But it's important to highlight that states participate in a given international treaty voluntarily. No states can be forced to become a part of a treaty. But if you have internal political will of being a part of it, they should do it in a way that in which they'll have to look at their internal law and already think of how they can harmonize international commitments with legal national commitments. What this doesn't mean that the international order is above the national order. The international order is one single order because there's just one international order. But when you mix this with national order, this brings these obligations that may come from a formal treaty, or they could have a harmonization through soft law, as we'll see ahead of us. But the issue is the state, once this treaty has been accepted, they should respect this, and once they are uh, and once they're really being applied, they should be followed rigorously. And Professor Jeffrey also mentioned this. Internal law can't be a justification for not following an international obligation. This is an obligation that the state itself signed on to when they ratified the Vienna Convention on the right on treaty law. So a part can't use its internal law to justify not following a treaty. This is very clear in international law. And in relation to a problem that is very common in some themes, the interpretation of treaties. The Vienna Convention also has general rules on the interpretation of treaties, which include the preamble. I think it was Isabella that mentioned this. It's the main content, the preamble, and the annexes. We have the general rules for the convention, but we have the special rules and the Cape Town Convention, and so the protocols also bring these interpretations along, as we'll see a little bit further on. And I think this is the way that the internal framework deals with international law. And this is a part of the executive power. This is in our constitution that it's only the president of the republic who can celebrate treaties. And when we're talking about the Vienna Convention for the international law, we have the Minister of Foreign Relations and other actors that were established by the state to participate in an international negotiation, and oftentimes this will be coordinated with internal institutions like ANAC does this at WASI, UniHydro A, and various international forums in which this is connected to the themes that ANAC works with.
So, since the executive branch, and I'm using inverted quotes, because the international society is decentralized and we are facing sovereign nations, and this sovereignty makes all of them share the interests that are common, and they try to find solutions that are interesting for all of the international community. So once a treaty is concluded, this treaty before being rectified has to be submitted to the National Congress in accordance with our Constitution, okay? And this mandate of the National Congress ends with a legislative decree. And the simplified agreements, they are not subjected to an authorization from our National Congress. And we have some agreements with the International Monetary Fund that illustrate that. When it comes to the CTC, we have the legislative decree number 135 of 2011. And then we have the enactment decree. And as my professor used to say, the enactment decree is a Brazilian tradition. So we depend on this enactment for it to become effective. And this has been happening for many, many years now. Why? Because only publishing the legislative degree could create a discrepancy, and people not get to know the content of that treaty. So the enactment decree is like a temporal lapse between the enactment by the National Congress and it coming into effect, and everything has to be harmonious with the international level. And when we go to the CTC and the protocol, the decree was issued in 2011, the enactment decree of 2013, but it came into effect on the 1st of March of 2012 because it was analyzed previously, but the enactment decree was not signed with when it was rectified. And other internalization forms and manners. We're talking about the transborder insolvency that was added to the recovery, judicial recovery, and bankruptcy law. To analyze all of the treaties for soft law, this is not necessary. You don't need to submit it to the National Congress. What did our National Congress do? They analyzed our legislation and now get the model law of 1997. Check letter A, paragraph number 1, and then paragraph 4 with letter D. Há alguma diferença? So we end up incorporating the content of the treaty that is almost identical. Of course, there are variations, but this instrument, since it is a soft law instrument, it's not submitted to any kind of control. We only need the National Congress to add it to our Brazilian legislation. And why do we have soft law and not sometimes the hard law? Legal framework. Why does this happen? Because of the interest of the several stakeholders. If our society is already complex because we have different political interests, imagine this at the international level because each sovereign state is going to defend their own interests. And so, if we don't consider all of the interests involved, we're going to go back to the Middle Ages where the strongest always prevailed. And we have, via the trade agreements, we have to try to have peace. We have the air sector, we have the services, and this works very well whenever we are at peace. Whenever we are at war, the situation changes radically, and we need to learn. We need to learn. We need what happened or was discovered in 1972. We only have one planet, planet Earth, and we are a single community in this world, a community of human beings, and everybody should benefit not only from the international legislation but also the internal legislation. And we have to promote this legislative harmonization. But there are other aspects that we must consider. The Convention about International Guarantees over Mobile Equipment. This convention establishes as an international obligation to promote a guarantee, an international guarantee of certain mobile equipment. And what is the most interesting about this convention is that it touches a point that we have private property at an international level. So we have aircraft, rail, trains, we have spatial devices, and we can facilitate international funding and they can have access to credit and they can move the international economy. And everything has to be safe, secure, and predictable. Within the interpretation of the CTC, in the fifth article, we're going to have that the interpretation should consider the purposes that are in the preamble, its international nature, and we need to promote a uniformity and predictability when applying the CTC. So in the Vienna Convention, we have a special law in the international law that establishes the uniformity and the predictability, and they have to be solved according to the general principles that it is based on. Not only the principles that are established within the NITROA among the several international organizations that must be coordinated, WASI, OECD, and other international organizations that coordinate converging topics. And also the relationship between the convention itself and the protocol, because we may have different interpretations. It says they must be firstly interpreted as a set, as a single instrument, and if there is a discrepancy, the convention is going to come above the protocol and the private international law. As an institute that is going to harmonize the private law, we have public and private aspects of the law within the convention, and it promotes The convention, the protocol, they promote a harmonization of the international public and private law. It establishes international obligations to the sovereign states, and it also establishes to private parties, mainly creditors and debtors, certain obligations that come from the funding contracts, that are a result of the funding contracts. And it presents substantive rules regarding the aircrafts. So, what does the private international law have to do? Determine the applicable law, determine the competent courts, recognize the execution of a foreign sentence or decision via international legal cooperation. Okay? And in the interpretation of the applicable law, they are references of the national norms and rules of the applicable law. And we also have to choose the jurisdiction of the forum. The main private international law that we have is a law from 1942. That's the main one, but it's not the only one. We should have already amended that when we created the Civil Code in 2012. So it's a very, very old law. Panama has a private international law code, another country as well. They discuss several topics, but we have private law in the Civil Code, also in the Civil Procedural Code, and we have the Brazilian Aeronautical Code, among other norms. And we also have a bankruptcy law. And what is interesting about this protocol? It highlights the autonomy of the parties. This is a principle that is not 100% clear from Article 9. The law that discusses the obligations is at the place where it was constituted, and it's a restricted interpretation by the court. So we urgently need to amend or review the LINGB and think about another legal instrument that is going to better suit Brazil. And the 8th article says the parties within an agreement, they can choose which law is going to guide their contractual rights and their obligations, totally or partially. And so we have to analyze the 9th article. The probability is small, but there is a probability because it's not clear in the CGB. I think she's saying CGB. Regarding the jurisdiction, this is another interesting point. We have the autonomy of the parties. So in the international legal mandate, it also establishes that the parties have the right to choose the courts that are going to analyze their lawsuit. It can be exclusive or not. When it comes to the concession of cautionary measures, Article 43, based on Article 13, so they have the authority to grant cautionary measures. But as Professor Marcelo Dinardi mentioned, mobile asset moves around the world. And what should we do about that? And in the second paragraph, letter B, they say they can only be executed in the hiring state. And Brazil made the declarations that were discussed here during the event already, and they set forth the deadline, as was mentioned before, 10 days. Challenges: the extraterritorial efficacy of a foreign decision. We also discussed this in a previous panel, and we do not only need efficacy, we also need to be fast or agile. So the national law can facilitate this exemption of homologation. Thinking about the international level is another possibility, but it's way more complex to convince the other states to adopt this measure. And at the same time, if we don't have a mechanism to exchange information in a digital system, the time that this rogatory letter is going to arrive or alive, and it's not going to be fulfilled in 10 days. We have to think about a mechanism and think about this deadline. And this is not only a problem of unidroit. We also have 16 weeks, 12 weeks for the subtraction. 16, 12? 6 weeks, pardon me, 6 weeks. Nobody can fulfill that. Nobody can comply with that. And so complying with the deadlines is not only a problem of the CTC, but the issue is it's an asset or a property that can become deteriorated, and then the losses can become even greater. And it can generate the reciprocous people are going to feel upset reciprocally. But if the deadline is reasonable, as it was mentioned by Brazil, Brazil has not been complying with the deadline, but it's trying to get back or give back the property to the creditors. Regarding the international legal cooperation, even when there is an urgency, the STJ has the mandate to do that. According to our constitution, the STJ could share this with the state courts or to a federal judge. You would disseminate the homologation or ratification of international decisions or international sentences. And then we would have more appeals being filed in the Superior Justice Court. And the CTC does not present these instruments that facilitate the circulation of foreign decisions. But what is the obligation of the state? It doesn't establish the tool to do that. It only says that the state is obliged to do that because possibly at the time there was no political will to insert an international law and to have these cautionary measures.
Some themes were excluded, and these are clauses for indirect jurisdiction in relation to matters for commercial contracts, exactly in the types and topics that were stipulated in this convention. We would maybe need to do something similar, but that's just a proposal. But I also think that wouldn't meet the deadlines and the timetables, and also the need for a digital mechanism for communication between central authorities, which might ease some taking some emergency measures, but that would also demand a lot of time for a current solution. But that's something to be thought out. In relation to compliance, something that's interesting to see in the CTC is the creation of a working group. And this aviation working group today is a legal entity, a nonprofit, but it comes out, well, it currently collaborates in monitoring the compliance. And what can we see? It monitors the implementation of the CTC and the protocol, and it monitors trends to see whether the state is in compliance or not. Transparency in the sense of providing opportune information, risk evaluation to know whether this evaluation would have impacts for eventual funding or attracting investors to the sector, and it also promotes harmonization on the international registration of aircraft according to the CTC. And here, as we've mentioned in the very beginning of this panel, not only of this panel, but of this event, Brazil is one of is a country with an average rating. And in my conclusions, I like to say that we have a need for a new theory. What's interesting is what we were discussing, whether wouldn't we need an internal law to establish a review of what's in Article 59 by the legislative power, or if there would be an amendment to the federal constitution to put Article 59, constitutional amendments, international treaty, complementary laws, delegated laws, so on and so forth. That might be a solution to demonstrate the hierarchical position of the international treaties. This would give further trustworthiness and predictability to international treaties, not only for Brazil and the world. The trend in judges is to apply local law when they don't know about international law. We should also have limits of interpretation because the very text of the treaty talks about how interpretation should be done. And not an interpretation of the interpretation as should be done by interested parties and by the judicial power in some cases. This has gotten this has lowered quite a bit because there's a lot of work done by the AGU of and also by the CNJ, the National Justice Council, in relation to international cooperation and all the commitments that Brazil has been taking part in. Of course, Brazil is a continental country, and we have the state level and federal level judiciary systems. It creates a system of registration of guarantees, which brings trust to investments and also the autonomy of the will of the parts in relation to the complexity of public international law due to the plurality of intergovernmental organizations and non-governmental organizations. We have, for instance, an association of private international law, which is a part of UNHYDROA, and UNIDROIT is a part of the Hague Conference, as well as other NGOs which also participate as observers in these international forums. And taking into account the decentralized international society, it's interesting that each state should have inside their internal legal framework how to incorporate international treaties and their measures. And private international law is even more accentuated because other than the commitments with international treaties and themes connected to private international law, we also have the coexistence of the variety of legal orders in the states. If we have officially 193 sovereign states in the UN, we have 193 legal frameworks regulating a topic, and then there's a need to review, and we should think of a law that substitutes the law of introduction of norms in Brazil. International cooperation in law should also be considered, and we should have the promotion of the participation of international actors for compliance. And so ANAC and other interested parties promote compliance. Compliance is not just done by the working group for compliance. The state should do its role, should do its homework to make sure that we are in compliance with international treaties and what mechanisms are necessary for their implementation. And the exceptions which are allowed are those in which the state has made a declaration. So, with that, I would like to conclude, and I'd like to once again thank Anaki. Thank you so much for the opportunity to bring some reflections on the topic. As I said in the beginning, this is a very open theme in relation the relationship of of international law and internal law. But as an internationalist, I always say that international laws, well, exceptions are possible, but the public order is always international public law. That is that which is common to all countries in a globalized world. Thank you very much. Did I go over time? Any questions? Please give that young man the microphone. I'd like to thank you for the seminar. I have a question about the Lindby. Well, unfortunately for private international law, unfortunately for private international law, we have this more of a restrictive application for the parts to be able to really define what is the law that rules over the contract. But let's look at a hypothetical situation in which the rules of the LNDB, this obligation would happen in Brazil, but the parts had elected in the contract the New York or London laws. So the parts in the CTC, the parts can elect another jurisdiction, and so the parts will should prevail in relation to choice of law in contracts which involve aviation. My name is Reginaldo. Reginaldo, thank you so much for your question. I agree with you. I'd just like to bring an open problem in the new article, but not only does the Cape Town Convention, not only is it a special law which establishes and recognizes the autonomy of the will of the parts, we also have in arbitration the recognition of the will of the parts. But remember that when the arbitration law was adopted in Brazil, we had questions in relation to the Supreme Court questioning the constitutionality of the law in relation to Article 5 and Section number 35, in which the judiciary power couldn't help, needs to appreciate this. Well, it's a faculty and not an obligation, and so they said that the arbitration law should be considered. Well, the CTC is internal, so it's also a part of the Brazilian legal framework. But the new article can be used as a counter argument between interested parties saying that Brazilian law should be applied and not the law chosen by the parts. And this leads to a certain discomfort for international contracts when we should have good faith should be the prevailing factor, and when different parties to a contract want to invoke their own internal country's laws, well, good faith, that's a my word should be fulfilled. This is a basis of private law, and uh, contracts need to be respected. Thank you. Thank you so much, Professor Inez, for your participation. The organization of the event would like to inform you that pictures and presentations will be made available on the event's hot site. And now, to wrap up the event, we'd like to invite the superintendent of uh, of airworthiness, Mr. Well, I don't think we have a lot more to say. We've had 2 days of in this event with a lot of lessons learned, a lot of insights which we can bring with us. I think it's very clear that we have a lot of steps to take from here on out, but as a whole, I think everything that needed to be said should be said. So I'd just like to take this moment to thank the presence of everyone who's here, everyone who participated virtually. I'd also like to thank the organization of the event. I'd like to thank all the staff who work with us so that things happened and continue to well here. Asconki always supports us in our events. I'd like to thank our international guests. Above all, I'd like to thank these two colleagues, the wonderful colleagues of mine who organized this event. Without them, we nothing would have happened. So Natalia and Luciana, please come up to the stage. please come up to the stage. I'd like to break protocol a little bit, but I'd like to ask you for a round of applause for their efforts in organizing this. Thank you so much for participating and have a good trip back home.